Hello, everyone. My name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm. Today is Thursday, August 31st, 2023, the last day of the summer months, and I have this live stream every week at 12:30 p.m. New York time on the topic of immigration matters. I do discuss the immigration topics and then answer all of the questions from our audience members. Anyone joining us, please post your questions in the chat section. I will answer all of the questions. Again, my name is Ismail Shahtakhtinski, and I'm the principal immigration attorney from IS Law Firm and the principal attorney at IS Law Firm. I'm a member of American Immigration Lawyers Association and practicing attorney. I've been practicing immigration for 16 plus years. So today's topic is Mandamus Action, the federal lawsuit against the USCIS to expedite the processing of your asylum interview. So as we all know, asylum interviews are stuck and significantly backlogged and delayed, and it takes significant amount of time for the USCIS to schedule asylum interviews. In some cases, we have clients waiting for 6 and 7 years for their asylum interviews. So as you all know, there is a regular expedite process for asylum interview. We're not going to go into that, but typically what you can do to try to expedite your case is prepare documents in support proving that you have either some significant humanitarian reasons, for example, you have family members stuck abroad, or you have some medical reasons. There is either significant reasons that why your case should be reviewed first. In those cases, you can file the expedite request directly with the USCIS asylum office that has your asylum case. You can email the asylum office, explain the reasons. Your attorney can prepare this and email it to the asylum office, so they approve it on case-by-case basis. The second type of the expediting second method of expediting your asylum interview is filing a mandamus action in federal court. What is a mandamus action? It's basically a lawsuit against the USCIS for violation of the federal regulations. Because according to the federal regulations, the US government must schedule asylum interviews typically within 45 days, and they must issue a decision within 15 days from the interview. So within 60 days from the date of filing of asylum, according to the regulations, you need to have a decision, which is either grant of asylum or referral to the immigration court. But because of these backlogs, as you all know, it takes many years. Therefore, there is a chance to file a lawsuit in federal court against the USCIS to force them to schedule your interview faster. Now, to do that, you need a lawyer who's admitted in the federal court that has the jurisdiction over your case. For example, here in Virginia, it's a federal court, U.S. District Court for Eastern District of Virginia, and I am licensed there, and the mandamus action will be filed there. There are filing fees of approximately $420. The legal fees depend on the case by case. Typically, it's anywhere between $3,000, $5,000, $7,000, depending on the case. There are multiple different lawyers that handle specifically mandamus actions, and sometimes we refer our clients out because those lawyers, they handle a lot of these cases, and it may be more affordable to work with them, or they can expeditiously do this. Now, should you use this mandamus action? Should you file a lawsuit against the federal government, against the USCIS, to force them to schedule your interview? That's a question that you should be asking your lawyer. Now, if you don't have a lawyer, I'll be happy to help. You can contact us at the links below, and we'll be happy to help you. We'll be happy to, schedule a consultation and talk to you. But typically, you and your lawyer would know about the basis of your case. So I usually say that if you have something questionable about your case, if there is any kind of uncertainty about your case, then there is a chance that mandamus action can make it worse. And here's why. Typically by law, the government shouldn't take any, shouldn't punish you for filing this mandamus action. It is your right and you can do so. So typically there should be no retaliation. They should not deny your case because of this if you file a mandamus action. But I've seen in the past where the government exercised its discretion in the case where it can exercise the discretion, in the case where there are some facts which the government can interpret one way or another. In the cases where there's been a mandamus action, they scheduled a quick interview and they gave a quick denial. Or in one case, at least in one case in my record, the case has been immediately sent to the immigration court without even a chance for the interview in the case of filing a mandamus action in federal court. Now, there were some complications in that case, and in the end, it actually worked out better for us. We got that case expedited in immigration court, and we got a quick grant of asylum through immigration court. But again, if you had some questionable aspects of your case, whether it's a good idea to do mandamus or not is something that should be addressed case by case. But typically what happens is once you file a mandamus action in federal court, the USCIS, the US federal government, has to assign a federal US attorney, so to speak, a prosecutor in federal court who will be defending the case. And because these US attorneys' offices, the federal prosecutors are as busy as the immigration officers and the government attorneys in immigration courts, they don't have interest in trying to defend something which they're doomed to lose, because it is true that according to the regulations, the USCIS has to schedule the interview within 60 days. So because of that, they usually settle the case. So if a mandamus action is filed in a federal court, typically it ends in a quick agreement with the opposing side, with the U.S. attorney, where they contact the USCIS office, the asylum office, and force them to schedule an interview as soon as possible. For example, we have a case which recently, just a couple of weeks ago, mandamus action was settled, and the USCIS scheduled an interview initially for the February of next year for this client, but then they contacted me recently and asked if we want to do it much earlier, which could be sometime in October of this year. So, again, to summarize the mandamus action, it's a case-by-case decision whether you should file it in the federal court to force the USCIS to schedule your asylum interview faster, or, you shouldn't do it if you have some complications about your case, especially if the officer can have a discretion, and they do have wide discretion on interpreting the facts or, deciding one way or another, because asylum is it's a discretionary grant, and there are many different issues for the officer to consider. They can think one way or another, interpret it one way or another. There is credibility evaluation in the asylum interviews, asylum cases, and so on. And that's very subjective to the officer's perception. So consider all this and talk to your lawyer. And if you decide you want to file a mandamus action, it's best to contact the lawyer that actually specializes in that, does these mandamus cases, and then they can handle it. Now, the mandamus action doesn't only apply to the case of asylums. Doesn't only apply to asylum cases. It can be used also to process your citizenship case, your family reunification case, if they're stuck beyond required maximum processing time. So, you don't want to file a mandamus action just because your case, you want your case to be heard before others. Or you shouldn't file a mandamus action in federal court just because, your case is stuck because of the priority dates, which is the limited number of green cards issued per year, which is, you file a petition, for example, for your child who's over 21 years old, and then you have to wait for about 6 years. Mandamus action is not going to move that forward. The Congress has to take action to change that law. For anybody who joined recently, again, my name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IS Law Firm. I am an immigration lawyer. I have more than 16 years of practice experience. with IS Law Firm, and I am a member of American Immigration Lawyers Association. Every Thursday at 12:30 p.m., we have this live session where I answer questions from our audience and briefly discuss an immigration topic, tell you guys about immigration news and developments. And today's topic is a federal action in federal court, a lawsuit in federal court that you can file to get your asylum case finally scheduled for an interview at the asylum office if you've been waiting for a long time, which many of the applicants are. To my information, there are more than 500,000 cases right now still in the backlog, pending in the asylum offices, waiting for the asylum interviews. Now, to expedite it in a regular way, as I said, if you want your case to be expedited because you have basis for it, other than just that it's taking so long, then you can file an expedite request directly with the USCIS, which we recommend doing, and they're liberally granting those requests, I have to say, depending on the asylum office. So you would contact the asylum office, provide all of the information, and request to expedite your asylum interview, and a lot of times it works. So if you have that and you want to look into it, let us know. We'll be happy to help you. When you expedite your asylum case, you need to make sure that your asylum package is complete, that all of the documents, your declaration, everything that needs to be filed is already complete and filed. Because if you don't, then they schedule your expedited interview, then you may not have enough chance to actually gather documents, country reports, and so on, or to update your asylum application or declaration. So you want to do it ahead of time, preferably even before placing an expedite request. We in our office, we usually like to first send those updated package, notify the asylum office that, this is the updated documents, updated package, and then immediately follow with the expedite request, telling them that we just filed the complete up-to-date information, that, the case is ready for the interview, and they would typically do that. They would often, grant an expedite request and schedule an interview. Again, as long as there are strong basis for that, as long as there are reasons. So for anybody who joined recently, thank you so much. Please post your questions. If you have any questions, doesn't seem like there are many questions, I will answer as much as I can. Today may be a brief one, and that's good because I'm about to leave on a trip, but I will do my best to answer as many questions as I can. If you have any questions, please post it in the chat section, or any comments, you can make it here, and I'll be happy to answer. All right, so Karim is asking, hi, Ismail, what type of referral from USCIS easier to win in immigration court? Referral states that I didn't prove that I had persecution or will have, or number two, your case deemed not credible. Hope you get my question. Karim, yes, thank you for your question. That's a very good question, actually, because the answer is simple. It's the credibility. Credibility is the most difficult one. And if the officer refers your case and indicates in his or her decision and notes that they found you not credible as a witness, it is then more likely than that the government attorney in immigration court will have the same, kind of predisposition beforehand and will question your credibility. And that is usually harder to overcome, not only in immigration court, but also in appeal. If the immigration judge also finds you not credible as a witness, those are more difficult types of appeals to win because they have a very wide discretion, because immigration judges and traditionally they're given a lot more weight in their decision about credibility than, for example, the law. They can make more mistakes in the law, but in terms of credibility, because the immigration judge is the one who observes, face to face during the hearing, the demeanor, the body language, and so on of the applicant, of the witness. That's why they're given a lot more wide discretion to decide on the credibility. So yes, Karim, to answer your question, credibility is bigger issue than that you didn't prove that you had persecution or will have in the future. A lot of times the asylum officers make mistakes in the law. They believe that something doesn't rise to the level of persecution. I recently had a case where a client of mine, had a gun put on his head, who threatened to kill him, and they took him to a station unlawfully and so on, and they interrogated and threatened him. And the USCIS officer made a decision that this did not rise to the level of persecution, where there is actually direct case law on that specific matter, that being a gun pointed at you does rise to the level of persecution, as long as this was an unlawful type of action where they were actually arresting him. There was no question that he was being arrested for his expressing his views, his political opinion, and at that point he had a government operatives point a gun at him. So this was a clear error on the USCIS officer's part. But the unfortunate thing is that once the case is referred to immigration court, the USCIS officer makes that decision, and there is no procedure to question the decision of the USCIS officer. You can file a motion with the USCIS office, but because they sent the case to the court, they're not going to do it. They'll just say, we already sent it to the court. Let the judge decide. You can go and argue it in the court. That's very unfortunate, circumstance within the system, because it's almost like there is no checks and balances before you have to go to immigration court. Now, the government may argue that immigration court itself is a checks and balances on the officers, because it is still part of the executive branch where the government is testing itself. So the Department of Justice, which is where the immigration courts are under, checks the decision of the Department of Homeland Security if they're not willing to grant your asylum. So basically, DHS sends the case to the Department of Justice for the court to decide on it. But still, the officer, shouldn't make this legal decisions erroneously without giving you a chance to respond to it. But that's the system. So if your case was referred on credibility, you have more questions by the government in immigration court stage. If it's based on the law, sometimes I have cases where we make arguments in the filings in immigration court, and we come to the individual hearing, and the government attorney simply tells us that they agree that the applicant deserves asylum. There's going to be no hearing. They'll just agree it, and they'll grant asylum by the agreement. And we tell that to the judge, and the asylum is granted automatically without a hearing, because we prove that the officer made a mistake. And sometimes the government attorneys, the prosecutors in immigration court, are not as friendly or as cooperative, and sometimes we have to argue the whole thing in front of the judge. So it's case by case. All right. Passibig is asking, what is the best and short way to get my green card? I'm asylum granted and also married U.S. citizen. Thank you. So if you're granted asylum, you can file for a green card at any point. We typically recommend to wait 3 to 6 months. So in the past, you had to wait 1 year before you filed for your green card after the grant of asylum. But because USCIS has significant backlogs, which often take about 2 years or more for the green card based on asylum, the USCIS recently announced that they will accept the applications even before the 1 year physical presence is satisfied. Initially, it was vague, and the interpretation was that you still have to wait 1 year, calendar year, to file it, and then just if you missed some time because you traveled abroad, that would still be okay, as long as you catch up and accumulate 365 days by the time the USCIS reviews your petition. But then USCIS made it a bit more clearer. I guess they realized that it was confusing at the initial announcement. And now the new announcement, new policy manual states that basically you can file for your green card immediately after you're granted asylum. And because it takes so long, at least 1 year or more, by the time the officer actually opens your case and reviews your green card case, you will already have 1 year of physical presence in the United States, as long as you stayed in the US during that time. And then your case is going to be approved. The reason why we suggest to wait 3 to 6 months before you file after the grant of asylum, before you file for a green card, is because there is still a slight chance that your case somehow can go fast. and somebody can review your case much faster, or they may clear the backlogs. And magic can happen, and the USCIS may find a way to hire more officers or clear the cases much faster. And in that case, then your application would be denied because you filed it before, way early, and by the time they review your case, you don't have 1 year of physical presence. So that would be problematic, and if that's the case, then the USCIS can deny the case. That's why we don't recommend filing it for approximately maybe 3 months or more. For anybody who joined, please post any questions you have, any immigration questions in the chat section. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IS Law Firm. I'm a member of American Immigration Lawyers Association, and I practice immigration law for more than 16 years. And here I am answering to the questions from our audience. You can post any questions you have in the chat section, and I will answer as much as I can. All right. Now, if you're married with a U.S. citizen, you can also file for permanent residency through marriage with a U.S. citizen. That is typically faster as long as you file all of the bona fides, all of the supporting evidence, including your medical examination report, timely at the time of filing. If not, then they will issue requests for evidence. It can cause more delays and more wait time. So when you file based on marriage with a U.S. citizen, you have to file significant amount of documents. There are multiple forms, and all of that has to be filed together. So based on that, you may be able to get green card based on your citizenship much faster than based on your asylum. In some cases, recently, it took our clients about 8 months of waiting time for their green card, 8 to 10 months, as long as there was no interview scheduled, and they did it faster. Now, since you had asylum case, there is a good chance that you will have an interview scheduled. And if the government does schedule an interview for you in your marriage-based case, that will delay the case. So in that case, it may take anywhere between 12 to 18 or 24 months. So to answer your question, in summary, pass big, or you can do either way. Typically, if you've been granted asylum, I do recommend filing for green card based on asylum, because on the marriage, depending on the length of your marriage, you may get a 2-year green card based on asylum. You're going to get a 10-year green card. And if you file it based on asylum, although it takes about 1.5 to 2 years or more of processing, that green card is going to be backdated 1 year. So you will wait 4 years for the citizenship. Although through marriage, you will only wait 3 years for the citizenship, but the green card itself is not going to be backdated. So if your marriage is solid, you may want to do the marriage-based. If you have any doubts, about the marriage-based process, then you can file it. You should file it through asylum. Okay. For anybody who joined now, thank you so much. Again, my name is Ismail Shahtakhtinski, and I'm the principal immigration attorney. I am here on our weekly live session answering questions from our audience. If you have any questions, you can post it in the chat section. I think my marketing team didn't join timely, or maybe they kind of missed this one, so they didn't post the questions from from social media channels, and that's why this session is probably going to be very short. In the beginning of the session, I spoke about filing a case in the federal court against the USCIS to force them to schedule your asylum interview. And as I said, it's an option to try. It's not an option. It's not a good option in every case, but in some cases, you may want to file it. You may want to explore that option to get your asylum interview scheduled faster by filing a federal court case, Mandamus Action against the USCIS. And in most of those cases, almost all of them get settled quickly, where the government goes ahead and files and schedules an interview for the client. All right, I see that there are no more questions in the chat section. I'm about to wrap it up. But for anyone who joined, thank you so much. Please press like. Please subscribe to our channel. On our YouTube channel, we post lots of videos, video blogs about the immigration steps, immigration procedures, immigration news. And you will be also notified about these live streams every week, which is held every week at 12:30 p.m. And you can send all your friends, colleagues, relatives, acquaintances, somebody who may be asking you immigration questions. You can send them here, and I will be happy to answer their questions. Again, it's every week at 12:30 p.m. New York time, Eastern Standard Time. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IS Law Firm. I see there is a question from Gabby. My case was re-adjudicated to the immigration court from Board of Appeals. Can I expedite my case? You can always expedite your case. So I assume what you mean, what Gabby means is that Gabby had a case in immigration court which was probably denied, or it may have been granted and the government may have appealed. In any case, one way or another, the case was appealed, and the immigration to the Board of Immigration Appeals. And the Board of Immigration Appeals sent the case back to the immigration court because of some errors. Basically, that's called remanded to the immigration court for the immigration judge to look into it again with some specific instructions. So once this happens, from the immigration court, we can expedite with that. So once this happens, the immigration judge schedules a new hearing date so that everything can be heard, or the specific parts of the case can be heard again. So Gabby's question is that, can you expedite that case? You can request to expedite every case. The basis for the grant of expedite are case by case, both in immigration court and in the asylum offices. So if you have some urgent humanitarian needs, maybe you have family members, immediate family members who are stuck abroad, maybe you have some medical condition, maybe there are some other reasons. So you can always send a request to the asylum office. In this case, Gabby, in your case, you would send it to the immigration judge in the form of motion. You can file a motion asking to advance it's called motion to advance. You would advance your individual hearing. So in that motion, you want to explain the reasons, and you want to, so Gabby wrote, yes, my kids. So I understand you have kids then abroad, and you have this case, so you should file a motion. Now, I assume you have a lawyer. If you have cases in immigration court, I would be really surprised if you're trying to do this without a lawyer. But talk to your lawyer. They can file a motion to advance, attach that information, and ask the immigration judge to expedite your case so that your individual hearing can be held earlier than it is currently scheduled, or maybe they don't have a date yet. So do that. Yes, there is a good way to do it. And also, sometimes I talk to the immigration judge's clerk and tell them that, look, we have this case. Everything is ready, good to go. The applicant, the respondent has kids stuck abroad. We want to see if there is a window. If any window, please think of us, put our case as soon as possible. And these judges of the the clerks of the immigration judges and immigration courts have a significant power to be able to, calendar your case earlier than others. So don't, hesitate to do that. Dumas writes, hi, I'm watching in from Haiti. Thank you for always inform us. I want to know if for the asylum I do have to do the CBP. I assume, Dumas, thank you for watching us from Haiti. I assume you're asking if you need the CBP to enter the U.S. through CBP One app through the southern border if you want to apply for asylum. The answer is typically yes. If you want to apply for asylum, you must be in the United States. One way or another, you have to come to the U.S. border, or you have to have a visa to enter the U.S. to be able to apply for asylum. And the easiest way to do it, and the proper way to do it to enter the U.S. if you don't have a visa, is through CBP One app. You can download that CBP One app, register all your information, and then when you are in Mexico, and it only works if you are in the northern or central Mexico, so close to the border with the United States, then you can request an appointment. Now, it may take several weeks. It may take 3 weeks, 4 weeks, 5 weeks. Some of our clients report to us now it takes about 2 months for the CBP, Customs and Border Patrol, to schedule an appointment with you. And then you go to that appointment. About 98% of the cases, there are no detentions. If you don't have anything, any issues prior, criminal actions, or you're not in the list, in no watch list, you don't pose any national security issues to the United States, then you're not going to be detained, most likely. So the CBP One app is the easiest way to enter the United States to apply for asylum, that has been for many, many years, for decades, in fact. So if you are trying to apply for asylum, if you have basis for it, using the CBP One app is the proper way. And that's what the government is trying to do, because that's orderly way. They don't have to detain you. They know who you are. They register, they process you. You don't have to jump off the fence. You don't have to dig a tunnel or swim across the river or walk across the dangerous desert. So you don't do any of those things. And to try to enforce the CBP One, try to entice everyone to use CBP One app instead of going through illegal ways, the government also imposed a transit ban on those applicants who are entering the United States through other means, as I said, illegally, or they don't use the CBP One app and come to the checkpoint and ask for asylum. So in those cases, there is a transit ban, which means that you have to demonstrate that you could not have applied for asylum in any other country, including Mexico, through which you just entered. In the CBP One, it's presumed that you don't have this ban. It doesn't apply. You're presumed that either it was unsafe or it just doesn't apply. But without CBP One app, you're presumed that you could have applied there and you are not going to be eligible for asylum. So try not to use any other means other than the CBP One app if you want to come and apply for asylum. For anyone who joined, if you have any questions, please post. I saw some more activity, some more questions, and I will do my best to answer all of the questions. So Kelvin is asking, my brother applied for asylum through LGBTQ basis. He's gay and he has changed and married to a bisexual citizen because they both want babies. How likely is he to be processed? How would you manage a case when the client is in Arizona, and how much it would cost to work with you for a client who hasn't applied? So let me answer the first part of your question, Kelvin. So bisexual is one of the LGBT of those letters, specifically the B, lesbian, gay, B, LGB. So bisexuals are included in the LGBT group, and they are members of a particular social group. And that can qualify you for asylum as long as you have been or will be subject to persecution based on your membership, based on being gay or bisexual or whatnot. So, that's included there. Now, the bisexual, itself, it means that you can be with a man or a woman one way or another, and, they're married, they want kids. So I assume they are, he's a gay, but he has changed and married citizen. Okay, so I assume married. Oh, okay. So your brother is gay, but he has changed and married to bisexual citizen. Oh, that can be questioned. But again, it's not necessarily a denial, but that raises questions. So what you're saying is your brother was gay, but now he is married to a woman, right? To have kids. So as long as that woman knows this, so I would get, her testimony. She would be probably a star witness in the case, because that's the question. Does she know that he was gay? Is he still gay, or does she know that he's gay? What's the relationship? So all of that is a factor. So that's how I would handle. I would try to find as much information and proof and witnesses and evidence that your brother was really gay and he is really gay, or maybe he was gay, he thought he was gay, but he's now bisexual. I don't know. So all of those things would be important, and without knowing all of the details of the case, I cannot tell you exactly how I would handle. But again, the most important evidence in every case is the testimony of the applicant, the testimony of the respondent, and then of the witnesses, those evidence of objective evidence, and obviously the country condition reports and so on. So that's how I would handle it. Now, how would I manage a case in Arizona? That's not a question at all. Now all of the immigration hearings are conducted online. There are some judges that prefer in-person attendance, but most of them don't. And in fact, all of the judges, including those who prefer in person, they are mandated to allow remote attendance. So basically, bottom line, because it's now 21st century, the immigration courts are not limited to in-person attendance. They allow video conference attendance. Just like now, in the past, probably many years ago, you and I would be sitting face to face in some conference room. We had to be only limited in the location, in proximity to each other, for you to be able to listen to this, lecture, if you want to call it this way, or this seminar on immigration, on this question answer session. But now we can do it through video conferencing, and the same applies to immigration courts, asylum offices, USCIS offices. I represent clients from all over the United States. In fact, most of my clients come from different states. And in fact, many of my clients are actually abroad. They begin contacting me and start working with me while they're abroad. I consult with them via telephone, Zoom, WhatsApp. We start working on their documents and cases, and I represent clients remotely all over the United States. Now, in some cases, clients prefer that I fly there in person. In fact, next week, I'm flying from here, Virginia, to California, to Los Angeles. I have an individual hearing in a case where the client decided that they want to have me in person, which is their prerogative, and they can do it, and I am happy to do it. So, there are many options. So Arizona, I've been multiple times to Arizona to the immigration hearings there, and we'll be happy to help. There are contact information here and at the bottom in the comment section or description of this video. So I'll be happy to help. Gabby writes, thank you, Gabby, for your questions and your patience. Dumas wrote, thank you, Dumas, also. And how can I contact you, please? Let me do this. I think there is some reason why the marketing team was unable to join or post the questions. Dumas, I just posted in the chat section the link for contacting and for scheduling consultation. We charge consultation fee, but that gets deducted from future fees. So if you go to this link, you can click on this and you can read all of the question answers about the terms of consultation, how it works. And if you click schedule a consultation, you'll be taken to a calendar. You will see all of the available times. Unfortunately, my times are not are very limited for the next, I think, week and a half or so. Part of it is because I have several hearings coming up that I'm going to be absent. And part of it is that I'm also going to be absent for my personal reasons for several days. So the earliest consultation I may have maybe in a week or two. Okay, so the next question I have is Ibrahim is asking, please, how can you know that your lawyer has applied your asylum or visa? So let me understand this question, Ibrahim. So you have a lawyer and you're trying to ask me how you can find out if your lawyer has applied for your asylum or visa. First of all, I doubt you have a lawyer. If you cannot ask your lawyer, or if you're not able to know what your lawyer does, that's not a lawyer. That's probably somebody who's pretending to be a lawyer, somebody who's not a licensed attorney. They're just scheming you and they're scamming you. They're just taking your money, and that's very dangerous. You don't know what they're gonna file for you. You don't know what they're gonna write, and then it's gonna be hard for you. You're gonna put yourself in defensive if they write some BS there, something that is not really your story, and that happens frequently. Then you're gonna have a lot of explanation to do. So and I understand legal fees, lawyers are not cheap in the United States, right? It's not. It's an expensive process. It's expensive for us to be a lawyer, to become a lawyer. We have to do get a regular education, then high school, then bachelor's degree, then another 3-4 years. In my case, I was taking Juris Doctor degree, took another 4 years after having my bachelor's degree. It's a lot of education, a lot of then, you end up with hundreds of thousands of student loans to become a lawyer. Then you take bar exams, then you struggle to find a job or to gather clients. And then you have office, you have paralegals, you have lots of expenses. So it's quite expensive for us too. And that's why legal services are expensive. Then you expect, to have a higher standard of living because you went to all these extra yards to become a lawyer, to get licensed, and so on. So, legal fees are expensive. And that's why a lot of people fall into traps of these crooks who are trying to, entice them to hire someone who's not a lawyer, to hire a paralegal who's not licensed attorney to, file their cases, and then they end up in this trouble. Don't do it. Talk to lawyers, talk to me. And we, the lawyers, we do provide as much as possible financial assistance to the extent that we can. We give additional reductions, discounts. Sometimes we handle cases on pro bono basis for those who we test and verify that genuinely don't have financial ability to pay for their legal fees. Again, to the extent that we can. So we do those things to help. But do hire a licensed lawyer. Having someone to help you handle your asylum case or any kind of immigration case by someone who's not a licensed attorney or accredited individual who's accredited as there is a process where a paralegal can go through accreditation and get an official accreditation that they can represent clients similar to a lawyer. So without those things, you're basically going to, almost like you're having a surgery done by someone who's not a doctor. It can cause severe complications. Same thing here. It can cause you life-changing circumstances. And in your case, you're saying somebody filed your case, Ibrahim, and you don't know who filed what for you for your asylum or visa. So if that's the case, get in touch with the asylum office. So Ibrahim writes, my cousin's lawyer says he has applied for asylum and work permits at the same time and is more than 150 days now, no any signal. Well, ask him to get a copy of the receipt. All of the asylum applications are filed online and you get a receipt almost instantaneously. So, once it's filed online, there is a confirmation that is given immediately. So if that's the case, then get a receipt, get a confirmation. And if that lawyer is a licensed lawyer and they're not cooperating, they're not responding to you, file a bar complaint, get in touch with other lawyers and have that lawyer force the other lawyer to release that information. Unfortunately, lawyers are not perfect. There are bad apples in every kind of profession. And I've seen lawyers do kinds of crazy stuff. Some lawyers get arrested for, doing illegal things. Some lawyers lose their licenses. So anyway, get in touch with another lawyer. If you want to consult with me or your cousin wants to consult with me, get them contact. And there is a link, as you see in this chat section. They can click here and schedule a consultation with me, and I'll be happy to look and see what I can do to help. All right. Gabby writes, is it a good thing that my case was re-adjudicated? Any info that I need to do? Gabby, again, you need a lawyer for your case. If you're asking these questions from me, it seems like, it's a good thing if you lost your case in immigration court and you filed appeal, not the government, you filed appeal, and the Board of Immigration Appeals sent the case back to the immigration judge saying, look at it again. It's a good thing. That means you partially won the appeal. Now, it doesn't necessarily mean you will be granted asylum or whatever you applied for, just because the appeals court sent it back to the immigration judge. But it means now you have a new chance, right? So, and a lot of times judges want to say, take a second look at it, or maybe you can take a second look at it. Maybe the first time you didn't have a good lawyer. Maybe you weren't prepared well enough. Now you have a second chance, second shot at it. So don't screw this one up. So get in touch with the lawyer. Again, I'm not trying to sell my services to you, although that's part of what we're trying to do, right? So we do all these live sessions and so on. It's a part of marketing tool. But you can find any lawyer you feel comfortable with, as long as they're competent, qualified, and that's the case where I strongly advise don't try to do it yourself. Okay, so I think there are no more questions here. Again, thank you so much for everyone who joined. Please press like, please subscribe to our channel. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IS Law Firm. I'm a member of American Immigration Lawyers Association with more than 16 years of experience. Every year, every week on Thursdays, 12:30 p.m., no matter where I am, whether I'm home, at the office, on the road, I do my best to, at the same time, to have these live sessions every Thursday, 12:30 p.m., Washington, D.C. time, New York time. We have these live sessions where I talk about immigration topics. I share the immigration news and I answer questions from our audience. So I have done my best to answer all of the questions. I believe I did answer all of the questions posted today. Please join us next week, and please send us here anybody you know who has immigration questions. Thank you so much, and have a nice rest of the week and a long Labor Day weekend. Bye-bye.